Hello and welcome to Tennessee Informer. I'm your host, Dave Vance. All of us know our country's in a mess. The threat of war, Islamic terrorism on the rise in America, the Fed-led invasion of our southern border, perversity and Marxism in our schools, out-of-control government spending, inflation, claims of looming pandemics, the climate change hoax, and the Green New Deal, just to name a few. There's a common denominator for all these issues. That would be the federal government. We are told that the Constitution makes all federal laws supreme to all state laws, and that the Supreme Court is the final arbiter of the Constitution. But is that true? Is nullification an option? These were topics of a lively debate Saturday at the Tennessee Alliance between two very accomplished attorneys, one of which will be our guest tonight. What about the incorporation doctrine of the 14th Amendment and the expansion of federal power under this post-Civil War amendment intended to protect the rights of recently freed slaves? Has it been used to assert power for the federal government? Here to discuss these issues tonight is Greenville attorney Jeff Cobble, who is also an expert on the U.S. Constitution and teaches numerous classes on the Constitution throughout the year. He's an attorney and counselor at law and the owner of Cobble Law Firm with offices in both Tennessee and Pennsylvania. He's admitted to and practiced law in this state and federal courts in both Pennsylvania and Tennessee since 1997. He completed his Bachelor of Science degree at Pensacola Christian College in Florida and received his legal training, earning his JD from Regent University School of Law in Virginia. He also earned a Master of Art degree in Education from Tulsa College in Tennessee. In 1986, Mr. Cobble was selected as one of the 16 educators from hundreds of applicants in a 5-state region to participate in a unique master's level program where upon completion he was named a Stokely Fellow by the University of Tennessee, an honor recognizing his outstanding contributions in the field of liberal arts education. Mr. Cobble has served as an affiliate attorney with a number of First Amendment organizations such as the Rutherford Institute, the National Legal Foundation, and the Christian Law Association, as well as the American Center for Law and Justice. He is also a member of the Federal Society and the Christian Legal Society. Mr. Cobble has been named as a life member of the National Registry of Who's Who, as a 2000-2001 member of the National Register's Who's Who's in Executives and Professionals. He serves as a corporate counselor and or trustee for dozens of local, state, and national businesses, nonprofit organizations, and for-profit corporations. Mr. Cobble attributes his success to the blessing of God, hard work, and good client relationships with his adherence to the Golden Rule. Jeff, thank you for being with us here tonight.
Glad to be here, Dave.
Well, it's always good to have you, and it was really good watching you in action Saturday at the debate. Really enjoyed it. We had a pretty good turnout, and it was a good event overall, I thought.
I thought so as well, and certainly lots of interested people. There were lots of questions afterwards, both in public and to me privately. So thank you for at least raising the issue. That's the important thing. We need to alert people to the concept of nullification and how we stand for states' rights.
Absolutely. Now, your opponent was Mark Pulliam, not your run-of-the-mill lawyer. He's a lawyer and writer who lives in East Tennessee and is a graduate of the University of Texas Law School, having practiced law in California for 30 years with a large law firm where he was recognized as one of the best lawyers in America. He now writes mainly on legal topics for a variety of publications. He has appeared in the Wall Street Journal, the Los Angeles Times, National Review, City Journal, American Greatness, the American Spectator, the Federalist, the American Thinker, and many other publications. He's also a contributing editor to Law and Liberty. He co-authored 2 legal treatises and writing articles in the Constitutional Commentary, the Wake Forest Law Review, and other scholarly publications. Throughout the 90s, Mark turned primarily to commentary in newspapers and opinion journals. His commentary and essays have appeared in newspapers across the country. Basically, the main thing the reason I wanted to talk about him just a little bit and put that out there is I want everybody to understand we didn't just go find some flunky lawyer for you to debate, okay? You were 2 high caliber lawyers discussing this topic. And I just wanted to make sure that everybody understood that.
Now, I'm the flunky as compared to those two lawyers. I'm the flunky. So
No. I like I say, I thought you did very well. Both of you expressed yourself well and made your points. I don't know if any minds were changed. Really haven't. Most of the people I talked to that were there, and I know several people there, but I certainly didn't know everybody, and I haven't had that discussion. I know some of them were already on our side and still are. I know some of them that were not on our side and are, I'm sure, still not. But I thought it was very good, and a lot of good points were brought up. And the main focus of Saturday's debate was nullification. Now, his argument was essentially federal supremacy and that the Supreme Court is the final arbiter of all constitutional questions, and therefore nullification is unconstitutional. That is the conventional wisdom. We both know that. We know we're in a minority, and you disagree. And if you could just, for the audience, point out some of the reasons why you disagree with that point of view.
Well, yes, the Tennessee Attorney General actually came up with the opinions, questioning whether nullification was appropriate. And the main thing that he raised, I think, is what Attorney Pulliam agreed with, which is that it violates separation of powers. And so let me address that really briefly. Separation of powers is the idea that certain things are assigned to one branch of government and another branch of government, or in Tennessee we call it a department. Another department of government can't do what the other two departments can do. And the Tennessee Constitution is very clear about that. The reason that separation of powers does not apply to this issue is that the idea of determining constitutionality is never assigned to the courts. Not in the U.S. Constitution, not in the Tennessee Constitution. It's a power they simply took for themselves. Under the United States Constitution, in 1803, Marbury versus Madison, the courts just basically said, someone's got to decide these things, so it should be us. And they found exceptions to that. For example, one of the questions is the political questions doctrine. There are sometimes the Supreme Court will take a case and they'll say, this is really something that should be decided in the political arena. For example, by elections or maybe by the vote of Congress. And they will refuse to decide a case. And I compliment them on that. What I say, though, is that when they come against litigants who debate the meaning of a statute, or particularly where the meaning of the Constitution is something that's at play, what I think they ought to do there is they ought to defer judgment as well. So they made up the doctrine in 1803. They made up the doctrine called judicial review, which really, if you want to be honest about what it really should be called, it should be called judicial supremacy, because they're claiming the right to review every action of the other two branches, plus all of the legislation and actions of the state governments, and determine whether they're constitutional under the United States Constitution. I don't know how you could define supremacy any more than that. I mean, that's supremacy. But they call it judicial review, and I really think it's a made-up doctrine. It's not in the Constitution, and if you read the Constitution carefully, you'll notice that it's not there. So I just wonder to myself, why wouldn't they have made up a different doctrine? For example, let me give you one for an example. Why wouldn't they have said, we're going to go with the we're going to make up a doctrine called congressional referral? That is, we're not sure what the language in this statute means, so rather than trying to decide, we're going to refer it back to Congress and let Congress tell us what it means. Instead, what they do is they try to look at everything that they think is relevant and then make a decision. In my opinion, they only have jurisdiction, the courts of the United States, as well as the courts of Tennessee, only have authority to decide cases. And so that's one of the places that I differ with the Attorney General and with Attorney Pulliam, that I believe that they're trying to do. For example, in the case, the United States Congress would not be a litigant in that case, or the president would not be a litigant in that case, and as a result, they shouldn't be deciding anything affecting those two branches or departments. They just decide the case. And then, of course, the second argument was the concept of supremacy, which is Article 6 of Section 2 of the United States Constitution. And the Attorney General and Attorney Pulliam both said, the federal courts are supreme. And the answer is the federal courts are supreme, but only where that topic was given to the federal government under Article 1, Section 8, or a few other places. And they're not supreme other places. And so it's almost as if they treat the Supremacy Clause as being the federal government supreme, and the states have no standing. And that's a complete and erroneous, completely false and erroneous understanding of the Supremacy Clause. They're only supreme in federal issues. And how do you know what's a federal issue? You read the Constitution. You read Article 1, Section 8. You see what's given to them. You can read Article 1, Section 10 and see what's denied to the states. The few amendments, particularly the 14th, might arguably give a little bit more a jurisdiction in some areas to discipline states where they would perhaps be violating in violation of the Due Process Clause or the Equal Protection Clause. But otherwise, Article 1, Section 8 has not been amended. So the United States government only has limited jurisdiction, and therefore the courts of the United States government only have limited jurisdiction.
Right.
And so that's my argument about the Supreme Court. I go so far as to say the Supremacy Clause is not on their side. The Supremacy Clause is on our side, because the Constitution very specifically limits federal jurisdiction and leaves everything else to the states under the 9th Amendment and the 10th Amendment.
Right.
So
and they haven't been repealed either.
Version.
The 9th and 10th have not been repealed either.
That's right.
So just to clarify something here, because with the Supreme Court, so I mean, obviously they have a role. I mean, they were created for a purpose. Now, I don't agree what they claim they were created for, to decide everything, because that undercuts the rest of the document. But so what exactly is the Supreme Court in reference? Let's say you mentioned a minute ago the president. So in what situations would the Supreme Court say have the constitutional right to say something about an executive action?
Well, I believe they have the right to say something about an executive action, as I have a right to say something about it, and so do you.
Right.
But what they say about it, in my opinion, has no bearing unless it involves a litigant in their courtroom. And if it's a litigant in their courtroom, I believe they decide cases, and that's what they're doing. They're deciding cases that arise in law or in equity under the Constitution. Now, if the case involves if someone sued the president, then they obviously have a right to weigh in on what the president's done, because he's a litigant in the lawsuit. But just because the an issue's raised by one of the litigants in a case before them, and as a result of it being raised, they just feel that they can just move anywhere they want to in the universe of the federal government and decide what's constitutional and what's not. There's not one word in the Tennessee Constitution or the U.S. Constitution that says that courts are the final arbiter of what's constitutional. Neither does it even say that they get the right to weigh in on what's constitutional. That's all part of what they've determined to do under the concept of judicial review. So what I would say is this question came up. In fact, I believe you may have been the one to ask the question. I'm not sure. But someone asked, no, I'm sorry. It was one of the questions that our moderator gave us. The question was, who should be the final arbiter of these things? And I believe, in all fairness to Mark, and by the way, somebody say this, he was very kind and a consummate professional. And I really appreciated the spirit in which the debate was conducted. Yeah. And I hope he feels the same about the way I conducted myself. We were not angry at each other, no cross words with each other. Again, I hope your viewers, if they have an interest, will get a copy of the debate and listen to the evidence on both sides and make up their own mind. But the question was, who's the final arbiter? And I think he says, well, the federal government is the final arbiter about what states' rights are, plus the Supreme Court is the final arbiter of what the federal government says. And they ask me, what do you think? And I say, I believe that the United States Congress is the final arbiter of what the Constitution says and what it means and what the laws say and what they mean. And I believe as compared to the states' rights and jurisdiction left to states versus federal, that states are the final arbiter with regard to that. I don't think the states ever gave up their right to let the federal government decide what powers the federal government has. I think it's, number one, absurd, it's illogical, and I can't think for a minute that people who had just, look, 11 years ago, when they're ratifying the Constitution, only 11 years ago had they dealt with this Declaration of Independence, they fought a war to challenge the authority of the monarch.
Right.
Why would they put 9 monarchs or black robe? Of course, there weren't 9 original Supreme Court justices. Why would they do that? Again, they wouldn't. The states had many, many rights and powers, and the powers and rights given to the federal government were limited and defined, according to Madison. So that's my view.
So the Supreme Court, according to the Constitution, it has original jurisdiction on certain issues. And,
yes.
And so, but you're saying that doesn't necessarily mean they're going to decide the constitutionality of those issues. Well, I mean, I guess they would have to be, at least, especially for the, I just said the word and it ran away from me, the initial jurisdiction or the
original jurisdiction.
Original jurisdiction. So, yes. And there's different situations, anything involving the state and the federal government, well, not anything, a federal issue, something in Article 1, Section 8, where the federal government and a state are at odds. So how would that play out with the court? What would be their role?
Well, without knowing exactly the litigants, the identity of the litigants, and without knowing especially the arguments or the issues laid before the court, I don't know exactly how everything would play out. But I guess what I should say is that I believe it's very clear that Congress retains the final word on those things. And the reason that Congress retains the final word is because Congress can fire anyone in the executive branch through impeachment, and Congress can fire any of the judges, federal judges, through the impeachment process. And so they're the final arbiter. That's what they should have done when our courts began to violate the Constitution earlier on. They should have just fired those, removed them from office through impeachment. They did not give due fidelity to the Constitution, and certainly didn't honor the rights of the people.
Right.
So let's take let me think of a case. Let's take a case that comes before the Supreme Court, and it's one of the ones in which they have original jurisdiction. For example, under Article 3, Section 2, the judicial power extends to all cases in law and equity arising under this Constitution, and again, to cases. And later on, it's to some things that have to do with controversies in which the United States is a party, controversies between 2 or more states. So the idea there is if Tennessee has an issue with Kentucky, and 2 states are involved, then that matter can go before the United States Supreme Court. It's given to them as far as part of their original jurisdiction.
Right.
And so in understanding original jurisdiction, it means it's where the case starts.
Right.
Then, of course, the United States Supreme Court, it says in all other cases, they're given appellate jurisdiction.
Right.
And which raises the question, appeals from where? Well, appeals from the trial court. Well, where's the trial court? Well, that depends. Remember, at the time the Constitution was ratified, there were no lower federal courts.
Right.
So where would the cases have started? They would have started in state court. And then only if parties wanted to appeal would it ever get to the United States Supreme Court. And of course, the interesting part, and I believe you brought up this point during the Q&A time of the court's appellate jurisdiction,
right.
Article 3, Section 2, Paragraph 2, it says, in cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, again, there's a type of case mentioned. Again, it's not just any case, the case is mentioned. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make.
Right.
Now, so let's play this movie out. If it doesn't start in the Supreme Court, it has to start in another court, and the Supreme Court has appellate jurisdiction. Then Congress can say no appeals from state court, no appeals from anything except original jurisdiction. Again, the Congress has the authority to do that. It's one of the things that I brought up during the debate that not many people seem to understand, and that's the idea that we have co-equal branches of government is a fallacy.
Yep.
The branches are not co-equal.
That's right.
Our fathers intended the states, the people's house, the House of Representatives, the state house, which was originally the Senate was originally the state house until the 17th Amendment. They intended for the people's and the states' representatives to have the final say about all this. So you can make the argument, and I've made it before, and I believe it's right. What if the United States Supreme Court said any case under the First Amendment is not subject to Supreme Court appeal? And then what if they abolished all lower federal courts and left it only for state courts? That means if someone wants to challenge whether you can read the Bible in public school or whether you can post the Ten Commandments, they're going to file that in state court. And the state court, if there's no right of appeal and there's no other federal courts, then the state court becomes the final arbiter of that.
Right.
And I say that's a good thing because guess what? The people in my county, that goes before my state court, and he says that you've got to take the Ten Commandments down. They know where he lives. They know where he goes to church if he goes to church, right? And that's exactly what our framers intended, I believe, that the government rises from the people and is responsive to the wishes and needs of the people. And they did not want some big homogenous nation, which is really, quite frankly, I think one of the strongest arguments that Attorney Pulliam made, which I quite frankly completely disavow, but the idea that we've got to all be one.
Right.
E pluribus unum, he says, out of many one. Well, one what? One in everything?
Right.
And I completely reject that concept. Just one with regard to the federal topics, and let the states decide. I like competition between states. Let states decide what they want to do with driver's licenses and marriage and crime and punishment, and how they want to raise their own revenue, and stuff along the lines of even free speech and religion and stuff. Let the states decide those things, and then competition will determine which policy is the right policy.
Right. And for those who say that the Supreme Court is intended to be the final arbiter, so why would you make the final arbiter the branch that can have their appellate jurisdiction limited, and the branch that does not have the purse, and the branch that does not have the sword? Okay. And I know that Mr. Pulliam mentioned, or basically he repeated what the AG said about Jackson's comments about nullification in the 1830s. And you pointed out, of course, Jackson was a strange choice, since Jackson also, in modern parlance, told Marshall to pound sand over the issue of the Indian Removal Act. He said, okay, Marshall, you've made your decision, now enforce it. That's right. Driving home the point that they don't have the sword, they don't have the purse, and oh, by the way, the ones who control the purse also have the authority to limit their jurisdiction. And it would seem to me, if they were going to be the final arbiter of issues, they wouldn't be the ones that get to pick and choose what issues they hear.
That's right.
I would think it would be, okay, if you're the final arbiter, we got to have this determined. Okay? Normally, they don't take up something until they have at least 2 federal districts in conflict, and then they'll say, okay, we got to figure it out. So that doesn't make sense to me by their position that they would be the final arbiter. But now, have we deferred to them a good chunk of our history? Yeah, and a lot of times. But the thing for people to remember too is, as we've deferred and over the years, they have taken more power, not just for themselves, but for the federal government. So it's only got worse. We basically, and this is, I look at the federal government this way, the federal government and the courts. They are like a spoiled child. That little spoiled child that throws that tantrum in the grocery store, and the parents don't do anything about it when they're 3 or 4. Well, then when they're 10 or 11, it's even worse. When they're 15, by the time they're 15, they're uncontrollable. And beyond that, that's what we've allowed. So does that mean that because they've taken that power and because so far we've allowed them to take that power, does that make that power legitimate?
And the answer, of course, is no. Just because you've abused your authority for so long doesn't mean it's now legitimate authority.
Yeah.
So.
Yeah, or in this case, usurped authority. I mean,
yes.
they just took it, and they took it either for themselves or a lot of times for the federal government. And you know, if you read the Federalist Papers, they talk about how the court was supposed to be there to keep the Congress and the executive in line. Yeah, well, they haven't done a very good job of that. I mean, I'm going to be honest with you. I think that this supremacy mentality, the only thing more dangerous than this supremacy mentality in our country is the Marxism that we're dealing with now. And if you think about it, all of the threats that we face today in our country and all the problems, now obviously they all have a moral, you know, there's a moral component or lack thereof. I've got that. But when you talk about it through the lens of the Constitution, or if you're looking at it politically, it all goes back to the federal government. Pick a topic: illegal immigration. You look at the problems we have with China. Well, who built up China? Who enabled China to be a threat to us? You look at all the threats of Islamic terrorism in our country. Well, who's allowed them to come over here?
Right.
Inflation, our deficit, our debt. It's all now. Granted, we as Americans share some responsibility on these things because we have gotten used to the socialism that started in this country in the 30s under FDR. But hey, guess what? The courts encouraged, they allowed that. They bought off on a lot of the things that the federal government wanted to do. And people just defer. But to me, deferring to this idea that the federal government, every federal law is supreme to every state law, and that the Supreme Court is the final arbiter. And there's a lot of good people that we agree with on other things who believe this. That is one of our biggest problems. And we will never, with that mentality, we will never have a chance to fix this country if we keep that mentality, in my opinion.
That's right. Hey, just two quick comments on the things that you said. You're spot on. But one of the things that Attorney Pulliam, I believe, and the Attorney General also wanted to emphasize is what's called precedent or stare decisis.
Yes.
Which is the idea that this is already settled, you know, and so this court here's a case in 2024. Well, they heard a very similar case back in 2020, so they need to decide it the same way. And so I've formed an opinion about what the courts do with precedent. And here's the way I articulate it after reading many cases and watching courts and actually appearing in appellate courts myself. Here's what I've determined that the appellate courts do. In fact, I had one case just like this before the Tennessee Supreme Court. They always follow precedent until they don't. And that's the best way to explain it.
Right.
I had a case that I went all the way through with the Supreme Court case. I get to the Tennessee Supreme Court, and they reverse that prior Supreme Court case. So, again, it's another doctrine that they use as a crutch. The courts use as a crutch, or maybe I should say a club. They use it as a club when they need to use it as a club, and then when they don't need to use it, they don't. So they put it aside. Yeah. So, concept of stare decisis and precedent. Every case should be decided based upon truth and the rights, natural law, and the very text of the statutes in the Constitution.
Yeah. Now, of course, he also brought up the South Carolina nullification situation.
Right.
And his side will always throw that out as if, number one, as if that's the same thing we are trying to accomplish here in Tennessee, and it's not. Okay, there's not just one type of a nullification situation. And for those who don't know, and if I get this wrong, Jeff can probably correct me, but that situation was one state, and it was over the tariffs in 1828 and 1832, which, you know, most of the South resented because most of the benefit of that tariff did go up north. Well, South Carolina said that, well, you know, this is a violation of the Constitution because it violates the General Welfare Clause because you are using all this It's not for everybody's benefit. But that doesn't change the fact that the tariff, as bad as it was, and I agree it was abuse of a power, but the federal government did have the power to implement those tariffs. And the other thing is, South Carolina was saying, okay, we nullify something, then it's nullified for everybody. Well, that's not what we're saying. That's not what your bill does. Your bill is dealing with situations in Tennessee. We're not saying that's going to affect Virginia, West Virginia, Kentucky, anywhere. We're nullifying something in the state. And
right, that's right.
So they want to paint it with all the same brush as if there's only, they say nullification's been tried and it failed. Well, number one, it didn't fail because they did ultimately lower that tariff in the 1830s. It did ultimately get lowered, and that was the goal of South Carolina, was to get it lowered. But on top of that, that's just one situation, one attempt at nullification. That's not the only way to do nullification. Am I correct?
That's correct, yes. And I agree with your analysis. I mean, arguably, South Carolina was not practicing nullification as we define it, because my definition of nullification is that we are declaring the federal government does not have jurisdiction over an issue. South Carolina, I believe you described it correctly. They weren't claiming jurisdiction. They were claiming a misuse of federal power. Our position is that they have no federal power at all over things like education or parenting or marriage, or quite frankly, I don't think they have any power over religion, if you look at the First Amendment, rightly understood. So our position is that the federal government does not have authority, and not that they're misusing their authority. And so there's one important difference. And one other thing I want to bring up, I will say this: Mark Pulliam brought up a lot of good things that we need to be involved in to try to change. Elections matter. Try to get out and get good conservative, limited government people elected to office. And
right.
and I agree with all of those strategies. Let's fix our election problem, and election reform, and fix the border. I mean, we agree on, my goodness, dozens of things that we agree on. But our difference on this is, he basically says that no state can try to fix the problem within their own boundaries. We have to wait till enough states all across the nation want to do it, or until the federal government says we can. And so my position is that I don't need to wait. I'm never going to get California to accept my values, or pick a New England state that's going to accept my values. But nobody on the West Coast is going to accept my values. When the federal government has taken authority that it's not been given, I don't need other states' permission, nor do I need the federal government's permission to say, you don't have the authority and you won't do it in Tennessee.
Right.
So if we begin to approach this topic state by state, then I'm not that concerned about what happens in New Jersey, or what happens in Alabama, or even in Texas, because Tennessee is taking care of its own backyard.
Right. Well, and we might inspire some other states. Hopefully, we'd inspire other states
Sure.
to do the same thing. It's certainly more effective than one state doing it, but you have to. I just cannot understand. With all the damage that we've seen done, let's just say in the last 60 some years, of what the Supreme Court has done, and that's setting aside all of what they started really in the 30s. It started a little bit before then, and of course, we'll get into the perversion of the 14th Amendment here in a minute. But if you look at the things they did just from the early 60s, all of a sudden, we're going to take prayer out of school. Now, with the situation today, I wouldn't trust any school with a prayer, okay? But
right.
It's not the federal government's place to tell the states that in their schools there can't be a prayer. That's not the federal government's place, okay? It plainly says Congress shall make no law. Okay, well, so the restriction is on Congress. It's not on the states. So that should have been a wake-up call. Well, that didn't wake them up. So then you got the abortion decision, which, resulted in 60 million murdered babies. All right, we basically made in this country for 50 years abortion a right, a civil right for 50 years, because the court said. And then we basically erased all of 5,000 years of civilization of marriage being between a man and a woman. And these guys, all of the supremacists went along with it. They are saying that the court has the right to make those decisions. There may say, well, I don't agree with it. But you're saying if you are a federal judicial supremacist, you are saying they had the constitutional right to make those decisions. If you have that mindset, then you have turned over all authority to them. You really can't complain about what they do. Now, let's talk real quick about immigration, because I think it's a perfect example of how we have let them get away with something, and it's only gotten worse. The only thing in the Constitution is naturalization in terms of what the federal government can do. They set naturalization standard, it's got to be a uniform naturalization process.
That's right.
They didn't become the final word, the only word, the lead, so to speak, on the issue of immigration until after the Civil War. Sometime, I think, in the late 1860s or mid 1870s. Before that, the states had a say. The only thing the federal government did was make sure all of the naturalization laws were synchronized. Okay, you didn't have one state that said, okay, it's going to take you 5 years to be a citizen, another state that says it's going to take you 10, another one says 6 months. It had to be uniform. So they set the uniform standard for naturalization. They did not, nowhere in the Constitution do they have the right to tell a state, you have to allow this person in your state. You have, and that's another thing, they basically forced on the states that this idea that, you have to school the children of illegal immigration. You have to allow them in your schools. We've accepted this. We've got, and this goes back decades, you at least have to go back to the 30s, but decades of cowardly governors and cowardly state legislators, and really a lot of it has to do with misinformation. They thought the court could do that. They thought the federal government. We're in the mess we're in because of ignorance and cowardice, in my opinion.
Right. Well, look, if you think, of course, you talked about abortion, but if the courts are going to say that they can control abortion, where's abortion in the Constitution? Well, the thing is, they found it. They found abortion in the Constitution under right of privacy. Where's that? Well, it's not in the Constitution either, but they found it. Yeah. Where they found it? They found it in the 14th Amendment. And where does it say that in the 14th Amendment? And they zeroed in on equal protection of the law. Yep. And due process clauses. So you can argue anything in it. And I will tell you this, in my course on the Constitution, Dave, we spend 40 plus hours talking about different provisions of the Declaration of Independence, natural law, all these things. And I'm going to tell you you and your audience what I tell this course, the participants in the class. Under the current jurisprudence and the definition of the interstate commerce among the states, which is only supposed to be, rightly understood, a product that crosses a state line that they get under Article 1, Section 8. But under the current definition and understanding, they can regulate your bowel movements. And that's the truth. Okay. They can regulate anything because, your waste at some point in time might cross, enter the soil or dirt or get into the waterway and make its way across a state line, and they can regulate anything. So when you allow them the power to define the terms and then the power to find things within the Constitution, you've completely ignored the 9th and 10th Amendments, which require an explicit transfer of power, an explicit limited jurisdiction, and it's completely gone. Yeah. So
before we get into before we get to the 14th Amendment, I want to go to that next, but I just want to hold this up here. This is a book, and it's a view of the Constitution of the United States, and this is not the whole publication, but there was a guy named St. George Tucker who was a contemporary of Madison. He was actually at the Annapolis Convention, not the Philadelphia Convention. The Annapolis Convention was, of course, a precursor to that. And he wrote the first book. He was a judge and he was also a professor. He wrote the first book about the Constitution in 1803. Now, let me set aside, he actually didn't write a book. He made it as an appendix to Blackstone's commentaries, which had to do with British common law, and part of what he was doing was adopting British, modifying the common law to the fact that we were now the people were now sovereign versus the king, and we were no longer subjects, but we were citizens. But it didn't get as much play. I mean, it was influential for till probably the mid 1800s. But he points out what you said. If it's not in Article 1, Section 8, and this is, of course, a paraphrase, then the federal government has nothing to say about it. The federal courts have nothing to say about it. If it's purely a state, and it really lays it out well because it talks about issues of concurrent jurisdiction, cases where the court might still come into play and say, hey, that's violating a enumerated power given to the federal government. In no state you can't do it. But everything else, if it's purely state, the feds have nothing to say about it. No branch of the federal government has anything to say about it. But I really should, and that's early on. That was the first book written, or the first treatise written about the Constitution after the Bill of Rights were added. Now, later on came Marshall, during that time came Marshall. And of course, Marshall was a big government guy. That's how you could describe him in today's terms. He was a big government guy. They were actually friends, but he was like, for any way to advance federal power, and that's exactly what Joseph's story was. If you ever read his views on the Constitution, read chapter 5, and he talks about rules for interpretation. Here's my translation. Refer to Marshall, who's expansionist at every turn, and find any and every argument to expand federal power. That's just my paraphrase if you read his rules. But a lot of what, and you mentioned this earlier, a lot of the problems we run into now is the 14th Amendment. Now, that came after the Civil War, and we do have the 14th Amendment on one of the slides. I didn't put all of it. I did put the first section and some other portions there, but talk about the 14th Amendment, and let's remind people that was most definitely done under duress and not in a constitutional way. Well,
actually, yes. There's no question it was done under duress. It was made a requirement for the states, the southern states, if they wanted readmittance to the Union. I've questioned sometimes whether they were. I think I would predict that if they knew then what we know now, they might have just said, we don't want back in the Union. Who knows? But yes, that's the idea, that it was, I think, ratified under duress. And of course, the 13th Amendment was passed without the participation of many of the southern states. And then the 14th was ratified, and that was done without, again, I believe, without the proper consent of the southern states. So I think there's a question mark on whether it was properly ratified.
And there's even some northern states and western states. New Jersey, they wouldn't allow New Jersey's senator to sit in that. They didn't allow him to be seated because they knew he didn't support it. And there was some of the western states, I think it was Oregon, after they found out how it was being done, they wanted to rescind their approval of it. Obviously that wasn't allowed, but it was not done. And it's, you mentioned the 13th. Well, that was done by December of 1865. And some of the southern states had already been re-entered back under the Lincoln 10% plan. Some of them had actually done that. They had agreed to, okay, because I think they knew that was going to have to happen anyway. But then they turn around and they're told, well, okay, you're not back in unless you approve the 14th. Well, wait a minute. If they're not back in yet, does that mean their votes, the southern states that did vote for it in the 13th, does that mean the 13th wasn't correctly ratified? Just a comment there, but
you're exactly right.
Yeah. So, but let's talk about the 14th, what it was supposed to do, and how it's been perverted. Let's put it that way.
Right. Well, I have an entire section in one of my courses, Foundations of the American Republic, which I think you've seen, and it's a couple of hours long, so we know we don't have that long. But basically, the thing that we want to focus in on about the perversion of the 14th Amendment, first of all, it did create dual citizenship. For the first time in our nation's history, people were deemed to be citizens not only of the state in which they were a resident, but also of the nation. And so federal citizenship is a new concept that the 14th Amendment addresses, and one needs to think that through as we deal with any laws and as we deal with any constitutional amendments that come after that, as it might pertain to citizenship. But the big issue with the 14th Amendment, and again, I call it the portal to the abyss. The 14th Amendment, I think, is the portal to the abyss. And I would be an advocate of appealing it, certainly in part, if not in whole. I don't know that that'll ever happen, but it's the source of virtually all of our misunderstanding today. So the basic portions of the 14th Amendment that give us the greatest problems are in Article, in 14th Amendment, Section 1, which has to do with the Due Process Clause and the Equal Protection Clause. So I think we've got those up on the screen there. Yes, I see this. So let's just read it so your audience can get it, get the flow. All persons born or naturalized in the United States, and subject to the jurisdiction thereof. Many people ignore that phrase.
Yeah.
It's a very important phrase. It's not there by accident.
Right.
Those are citizens of the United States and of the state wherein they reside. Now, it's my opinion, if you can just keep that up on the screen for a minute, and just let me talk while people can look at the language, that citizenship requires three things, the three elements, let's say. You have to either be born in the United States or naturalized in the United States. Secondly, you have to be subject to the jurisdiction of the United States. And thirdly, you have to be a resident of the United States and the state wherein you reside. Again, so the basic residency is required. Therefore, one of the biggest mistakes that we've made, and the Supreme Court has, I think, largely endorsed this concept of what's called anchor babies. And I'm sure you're familiar with that term, right, Dave? The idea that all you have to do is just swim across the Rio Grande and have your baby over here, and now your baby's a United States citizen. Yep. Well, the newly born child might be born in the United States, but that child is not subject to the jurisdiction thereof. That is, if they swam across the Rio Grande, they don't have a social security number, they don't have identification, they certainly aren't subject to our birth laws. They're not a resident. They're an imposter. They're an imposer, and we call them illegal. So in that respect, the whole concept of anchor babies it's completely bogus. I hope that your listeners here can see the three things that are required there. You have to be a resident. So if tourists come here and and they're here to see Washington D.C. and the lady's 7 months pregnant, or maybe 4, and has her child early, they're not entitled to citizenship, in my opinion.
Right.
So,
well, now that's a fairly recent interpretation that this whole anchor baby thing. I don't think that was a problem for most of the time since the 14th was passed. I think that's a late 20th century invention, isn't it?
It is, yes. Oh, yes, that's right. Proponents of immigration and have been pushing that since the 14th Amendment, quite frankly. So, but I just think it's a wrong understanding of it. See, Dave, the people who disagree with us on like nullification, for example, let's go back for a minute on that issue. The people who disagree with us on nullification want to tell us to read quotes or read opinions, but they don't tell us to read the Constitution.
Yeah. Read
the Constitution in whole,
right?
Not just that section, and then make it fit with other sections, and it has to agree. And when you do that, you're going to come up with the right understanding.
Yeah.
The problem is that in Marbury versus Madison, they just basically took the power. They didn't really consider the effect of the 9th Amendment and the 10th Amendment, and of course we didn't have a 14th Amendment at that point in time, but we did have the Bill of Rights. So on this 14th Amendment, the judges have just waded in here and they've twisted virtually any term that they can find to twist to push their agenda. I mean, let's just be quite candid about it.
Oh yeah, absolutely.
They're pushing their agenda, and they're finding something in the Constitution that they think will support it, and that's how it goes.
Yeah. We have a question from one of the audience. Okay, let me make sure. Okay, if two foreigners take up residence in the U.S., they work, pay taxes, they have the baby. Would that make the citizen, the parents, subject to the jurisdiction thereof, and the child be a citizen? That's the question from somebody in the audience.
Okay, and that's a great question. In fact, that's probably the most difficult of all the questions because we have clearly two of the three criteria, right? We've got the element of the child was born here, and then secondly, we have the idea of residency. So then the question is, are they subject to the jurisdiction thereof? And if they have, in my opinion, if they have come here legally, and you said they're working and they're paying taxes and so forth, then I believe they have subjected themselves to the jurisdiction of the United States. And in that particular situation, I would say that their child, in Jeff Cobble's courtroom, by the way, not that I have one, but if you were to ask me to decide, I would say I think that arguably that fits all three.
Now, but okay, but those parents, all right, we say they're here legally. Okay, obviously, if they came here through the immigration process and were, came here with the intention of being a citizen, versus let's say they come over here on a work visa. Okay, they're here on a work visa, they're both working, or maybe even a college visa, but of course they're working and going to college, and they're married and they're here and they have the kid. I think that's a different ballgame, isn't it?
It is, in my opinion, it has to do with what their intent is. So let's go back to a question that comes up in my office, in my practice occasionally, and it's right here in the first sentence of the 14th Amendment, Section 1, the idea of a residence. Well, so what's the standard? How are you a resident of Tennessee? I get this question a lot. A lot of people are moving here, and I say, look, if you're just driving from Michigan down to Florida, and you stop off at someplace there and get robbed, or you have an accident, you have access to the courts for us to vindicate, but you're not a resident. So right now, the rule, as I understand it, unless it's been recently changed, is that you have to be a resident of Tennessee, have to have been here for 6 months in order for you to be a resident. And so what does residency mean? The last I researched the issue, we determined residency based upon one factor, and that is are you in Tennessee with the intention to remain here indefinitely? And so it's really a subjective test. It's not an objective test. It's a subjective test. What do you intend? And if you said, I've been here for 7 years, but I don't intend to be here indefinitely, then arguably you're not a resident of Tennessee anymore. So residency is more than just being in a motel room or renting an apartment or even buying property. It has to do with one's state of mind.
Well, if you've been here for 7 years, you're a resident whether you intended to be or not, aren't you?
Maybe. It depends, I think, on what the issue would be.
Right.
But I mean, if you're here for 7 years, but if you're here if you say you're here on the student visa,
yeah, right,
or the work visa, or whatever the case may be, and you say, look, I'm just here temporarily, then no, in my opinion,
right,
you're not even a resident. You might be subject in some respects to jurisdiction,
right,
but you probably would not meet the residency test.
Right. And subject to the jurisdiction doesn't just mean if you're speeding you get a traffic ticket. That's not subject to the jurisdiction of. There's more to that term than that.
That's right.
But I, like we said, the 14th has been the culprit, and is it really the 14th, or is it a perversion of the 14th that has caused the problems, in your opinion?
Certainly the perversion of it has caused the problem, but still, when you think about the actual text of the Constitution, which gives Congress, now under the 14th Amendment, the right to discipline states. Remember, this is one of the first things that's ever come up in our country. All of the other amendments to the Constitution were to limit federal power. But now we get to the Civil War amendments, the 13th, 14th, and 15th, and what we find is that they now begin to limit state power. And so in that respect, the whole concept of whether the federal government of course, if you amend the Constitution and it's a legitimate amendment, you have to stand by that. It was a legitimate amendment. If it was, then the federal government through Congress. I saw that on the screen a minute ago. That's a good thing to put up there on the screen. Section 5 of the 14th Amendment. We bring this out again in my Foundations of the American Republic course, and it's a shocker to people because it doesn't give the power to the courts to enforce the 14th Amendment. It gives the power to Congress to enforce the 14th Amendment. But again, under judicial review, well, then we can consider anything in the Constitution. So that's in the Constitution, and we can kind of ignore the part that says Congress has to enforce it because of judicial review. So you see, they tag team judicial review on top of the Section 5 there and take power for themselves. But it's my opinion that the courts only have authority over any 14th Amendment issue. They only have authority if Congress has passed a law.
Right.
With the intention of punishing a state, which does give the Congress the right to enforce any state that does not afford equal protection and the concept of appropriate notice. So if you understand, the courts are just jumping right over the congressional part and doing it themselves, and I say it's invalid. They don't have the authority to do that. And only Congress was given the power to enforce the 14th Amendment.
And so if the court is not involved because of a law that Congress passed that ended up then it's what they're doing is just grabbing power for themselves. But it seems to me like they've done a lot of that. But now, and you probably, being a lawyer, know more about this than I do, but immediately after the Civil War, for the first really several decades, not to say that there weren't 14th Amendment cases, but I know in the first one, the first major one, the Slaughterhouse case, they still said that the Bill of Rights, which was originally a restriction on the federal government and not on the state government, they still said that was the correct interpretation in 1873. Okay?
That's correct.
Which basically means that what all the 14th Amendment was intended to do was say that, okay, look, you cannot have different laws for the freed slaves than what you have for the white population. So if this crime for a white person doing X, Y, or Z is a 10-year sentence, then it's got to be the same for a black person. That's right. For a free slave. That's what. Now it does say all persons, so it didn't just limit it per se to that, but it all basically comes down to you can't make separate laws. But once again, there has to be, Congress has to act. So if the state is doing something like that, Congress has to enact legislation, and if Congress hasn't enacted legislation, then the court can't get involved. Now, I do know, and you probably know this as well, that one of the reasons that they wanted to pass the 14th Amendment was because they had passed the Civil Rights Act, the Civil Rights Act of 1866, that had a lot of the similar, not exact same language, but the same intent, I guess you could say. And they were afraid that if they did not pass the 14th Amendment, that sometime down the line that the Civil Rights Act of 1866 would just be revoked.
Yes.
That was the intent of it. But it was never intended that the federal government was now going to be the entity, specifically the court, to determine what the First Amendment should be or to determine what the second. It just meant that you had to apply those things evenly to everybody. You couldn't have two separate set of laws. Not that, okay, federal government is now going to tell you the parameters of the First Amendment, Second Amendment, pick an amendment. That was the intent, correct? The original intent.
Oh, yes. There's no question that was the original intent. The actual language, again, the 14th Amendment, no state shall make or enforce any law, and then we'll skip the P and I clause. It's not relevant. Nor shall any state deprive any person of life, liberty, or property without due process of law. So the concept here is process. Your process must be the same. And like you said, we can't have one standard for one class of citizens versus another. The intention, of course, It says cannot deprive any person of life, liberty, or property without due process of law. But what they take is they take the concept of any person, and they're beginning to consider every element of personhood. For example, so life, liberty, property, and then they begin to describe something like a property right. So a state can't deprive someone of property right. And then what they do is instead of making an idea of just denying someone property, they basically have then reversed it and said, if you're not giving property to someone so that it makes it equal, right, then we don't have the equal protection of the law. Well, equal protection is a shield, right, not a sword. Equal protection means the state must defend each person within its jurisdiction, right, to the same extent. Not that they need to give the same benefits. Right. And again, the denial of life, liberty, or property is not the same as awarding people life, liberty, or property. Right. So they've taken these concepts that were originally to be negative. A state can't do this, and they took it and flipped the coin over and said now a state must begin to do these things.
Right, and that was part of what the incorporation doctrine, which really didn't start until decades after, correct?
That's right. That's exactly right. Yeah, the incorporation doctrine came along in the early 1900s, and oh my goodness, it has messed up everything. And for those that don't, I don't know if we have time to talk much about the incorporation doctrine, but the absurdity of the whole concept is that the 14th Amendment addresses issues of substantive fairness and equality, and because of that, we're finding that states are being unfair. Okay, they're being unfair about stuff, and because they're unfair, that can't be right. The 14th Amendment means we all want to be fair and even fair and equal. We have to be equal, and they even go to equal results. The concept of affirmative action's been based on the 14th Amendment. The concept of quotas been based on the 14th Amendment. It's this idea of equal results, and so what they've begun to find is that states were saying, wait a minute, you can't do that because the Bill of Rights protect our state. And so, when the 14th Amendment was passed, the drafters, and I guess they go so far as to say the states that ratified it, all intended, we know it's a lame argument, but their argument would be that they intended that certain parts of the Bill of Rights would be incorporated against the state. So here's a good example. Back to capital punishment. Remember, there was a time that the U.S. Supreme Court basically said the Eighth Amendment says that there is no cruel and unusual punishment. But up until that time, cruel and unusual punishment in the Eighth Amendment only restricted the federal government. The federal government could not utilize cruel and unusual punishment. But then they bring the 14th Amendment along, and they say, but the 14th Amendment talks about fundamental fairness and equity. And so we know that originally the Eighth Amendment talked about no cruel and unusual punishment, and it only bound the federal government. But now, because of the 14th Amendment, we're going to take the Eighth Amendment, pull it into the 14th, and going to incorporate the Eighth Amendment into the 14th, and now say that states cannot impose anything cruel and unusual. And it's not the state's definition of what's cruel and unusual, but it's the United States Supreme Court's definition of what's cruel and unusual. So they're piggybacking things in. That's what incorporation means. They're taking the Bill of Rights and they're selectively taking one provision and they're pulling it into the 14th Amendment and say that applies here.
And it turns the Bill of Rights on its head because it was supposed to be a limit on the federal government and not the state governments. And that's right. Like I say, the big gap in time from when when the 14th passed until they started this, I want to think the first case had to do with the First Amendment. I think that was not till maybe the 1920s, 1930s, somewhere around there. I mean, that's a long time for them to, they just weren't doing it right all these years. And of course, I thought somebody kind of brought that up the other night about the issue with abortion and I think marriage as well. And Mark's response was, they're not perfect. So look at Roe v. Wade. So that was 50 years. For 50 years, we said you have this right. For thousands of years, marriage was just between a man and a woman. But it's okay because the court has changed its mind. I mean, we're supposedly, we have an amendment process, okay? And we've had, 27 amendments, I think it is, over the years? Well, we've actually had more than that because if you look at what the courts have done, they have had, for all practical purposes, their decisions have been constitutional amendments. And then, oh, well, they just change it. And think about it, we're not even 250 years old. And for 50 years, abortion was a civil right in this country.
That's right.
And then, okay, they finally got it right and said, hey, we're going to send it back to the states. And, oh, well, that's the process that's the belief of all of the judicial and federal supremacists. That's just the way it is. And look, that's the majority. That's 98% of your lawyers, probably 99% at least of your judges. And most people, oh, well, if those lawyers and judges tell me that's the way it is, then that's the way it is. It's just insane to me. So I think the 14th Amendment, the perversion of it, has definitely been bad for our country. Anything else you want to say on that specific? Because I do have one more 14th Amendment question for you, or incorporation in general, if you want to hit on that some more for a couple of minutes.
Only one other thing I guess would be important. It's had a tremendous effect on a much greater effect than them abolishing capital punishment for the whole United States. For your audience that may not be old enough to remember, there was a time that every state had capital punishment. Then the federal government, Supreme Court, says capital punishment is cruel and unusual under the 8th Amendment, incorporated through the 14th, even though the 5th Amendment specifically references capital punishment. They ignored that part. So that's your audience that may not be old enough to remember. There was a time that they claimed the right to say that capital punishment could not be practiced anywhere in the whole United States for any crime.
Yep.
So that had some devastating effects. But the greatest breach upon the freedoms and liberties of the American people, of the incorporation doctrine, has been the First Amendment.
Yep. Absolutely.
And so, originally they said, it says Congress shall make no law. For 100 years plus, they knew that it meant Congress, it meant the federal government. But then they bring the First Amendment, just drag it in, kick it and screaming into the 14th Amendment, and say that now that's applied against the states. And so now it's a state that cannot do anything to establish religion. And by the way, it's not really the establishment of religion, it's just talking about religion. It's just even emphasizing religion. You can't do that either. And so it's through the incorporation doctrine that they've gotten to the First Amendment, brought it in to the 14th, then applied it against the states. And then they have the right to say, well, it's not just the states, it's cities too. Cities can't have a cross on their city seal. The police cars can't have "In God We Trust" on them. Yeah. Of course, schools can't have, so it's just been the bane of our existence. It's been the portal to the abyss, this incorporation doctrine. And so there's another good example. Now, the interesting thing is the courts have not yet incorporated all the Bills of Rights. I don't even know how you would incorporate the 9th and 10th into the 14th without just completely calling them repealed.
Well, they just ignored them. They pretty much undercut them. When you say that they are the final word, then the 9th and 10th mean nothing, and really the others mean nothing.
Exactly right. Exactly right.
We can never fix this country as long as we hold on to this doctrine. There's no way to turn this around if we have that doctrine, in my opinion. And I think it's a very dangerous and destructive doctrine that we've gone along with. I do want to say one more quick thing that you pointed out about nullification. Mark and all the others make it sound like it's just the end of civilization if we nullify something. But you brought up a good point, and I've heard it before, and others have heard it. But what about the states that are ignoring the federal drug laws? What about the states that for years ignored immigration laws? I mean, nullification is not the destruction. The courts in this lockstep mentality of all the federal supremacists that the court is the final arbiter has done more destruction to our country, caused more problems in our country, more division in our country than nullification could ever think about. And nullification is not secession. It could maybe help avoid that if we would actually start practicing it. It might actually, say, hey, yeah, okay, maybe we don't need to try to push that issue. But one last thing on the 14th that I want you to address, and then I want to hear whatever else you want to hit on, is, we talked about citizens under the 14th. And of course, to be president or vice president, you have to be a natural born citizen, which my understanding is the current vice president who wants to be president is not a natural born citizen. But let's talk about that a little bit.
All right. Well, yeah, there's a provision in Article 2, which is the section having to do with the president. Uh, and I believe it's the fifth paragraph. Let me just double check that. Article 2, Section 1, yeah, paragraph 5. No person except a natural born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Of course, then it was the 12th Amendment, I believe, that said the vice president cannot be vice president unless they're also qualified to be president. So I've been very disappointed that some of these First Amendment or Christian conservative organizations that like to litigate did not address this with Kamala Harris. But again, I'm not exactly sure about her heritage. I think there was Jamaica. Am I right? Is it Jamaica?
She's half Jamaican and half Indian. As I understand it, neither one of her parents were citizens when. Actually, I think she may have been born in Canada, but I could be wrong about that. But she's at best an anchor baby. But by today's standards, it's like, oh, that's okay. It's ridiculous.
Well, you're completely ignoring the requirement that the president, and by virtue of the 12th Amendment, the vice president also, has to be a natural born citizen. Now, that's important. I want people to understand it doesn't mean they have to be a citizen.
Right.
Okay? It means more than that.
Yep.
And it's more than just naturalized.
Right.
But natural born citizen has a specific definition. And the courts have tried to settle the issue. Of course, you know my position is that I don't think the courts necessarily have the right to settle the issue. I think Congress ought to try to settle the issue, and if it's not clear, amend the Constitution. But there's one of two arguments. The more well-accepted argument today, from conservative perspective, says that a natural-born citizen is a child who is born of a father who is the citizen of the United States. And so certainly if they're born here, if they're born in this land, they would be a natural-born citizen. Again, if they were subject to the jurisdiction, all those kind of things. But I believe the right understandings have to be born here and be born to at least the father being a citizen. Now, what if someone like John McCain, the issue came up with John McCain, I believe, who was in the military. His father was in the military.
Right.
And he was born outside the United States.
Right.
Then the question becomes, he wasn't born on the land, but he was born to a father who was out of the land in service.
Still a natural-born citizen.
Still. So
yeah.
So I'd take the position that equates to natural born.
Right. Yeah.
But there's another definition that goes back to Blackstone and even Blackstone's predecessors, which basically say to be a natural-born citizen, both parents have to be citizens of the United States. And so that's the big debate. Is it just the father only, or the concept of father only? I think comes from the law of nations.
Right. Patel.
Like Patel.
Yep.
Addressed that in the law of nations, which a lot of our founders gave great credence to. In fact, our John Jay, our first Supreme Court Justice, Chief Justice, gave a lot of credence to the law of nations. But the law of nations would say that the person is not a natural born, so they're not a true, he used the term, I believe, true citizen. Is not a true citizen unless his father was a citizen. But there's a strong argument from Blackstone and the common law going all the way back that both parents ought to be. But under either definition of those, then I believe that Harris was not qualified to be vice president. I think Obama was not qualified to be president. And not just to pick on the liberals, but for example, I don't think Ted Cruz.
Nope.
Who's a guy? I've been in Ted Cruz's corner for a long time. Has been a really good statesman, but I don't think he's qualified to be president under the natural born citizen clause.
Yeah, he's a good Canadian, but no, he's not qualified to be president.
No, he's a good American, but he's just not a natural born American.
Well, he is fully American now because he's not natural born, but he basically had to give up his Canadian citizenship in 2014 when he was going to be running. I remember that. So anyway, but yeah, there was a lot of people that were disappointed and didn't want to go along with that. But yeah, I don't think he was a natural born either. So two things real quick. Anything else you want to put out there? And also, you do several different lengths of different classes of different varying times. You got some classes or events that you want to discuss, or any other thoughts that you want to add before we go?
Well, I'd simply say I do have Foundations of the American Republic coming up in Greenville this coming Saturday. All of my courses are always free unless the people hosting the event are charging, but I've never charged. Certainly they're right if they want to charge. Someone told me, I think last Saturday after the debate, that I was scheduled to do one of these Foundations of the American Republic in Sparta. So I guess you can contact Karen Bracken about that. I know that you've had her on your program, and she can, or maybe you know about more details about it, Dave. I'm not exactly sure.
I think the Sparta class might be Danny Blitz. I think that's. I'm still waiting. Okay, so and now I don't have the current flyer on that. She's going to get that to me. So that I want to say is later in September, if I'm not mistaken.
I believe September. Yes.
Yeah. Okay. So we'll be advertising that for sure. But any other closing thoughts?
No. If people are interested in either learning more about the Constitution, I have a slew of presentations I can do. Some just extemporaneous discussion like we're having here. Others with more professional PowerPoint slides, Word documents, and pictures and graphs and so forth. But I can talk on just about any topic constitutionally from the federal perspective. As well as Tennessee. I would urge people to take an interest in the Tennessee Constitution. I'm available to do Tennessee Constitution courses as well. And again, no charge ever on my part. I just want people to know and understand. And also, I'm asked sometimes to talk to churches. And if churches want me to come and talk about liberty issues or talk about these political things, or even, quite frankly, talk about the scriptures in their church, I'm available to do that. I do a lot of church work, pulpit work, and those types of things, and talking about biblical Christianity and how we in the church age should respond to civil government, looking at things like Romans 13 and Romans 12 and a variety of other things. First Peter addresses authorities, and so I can talk about that. I think there's a lot of common, quite frankly, misunderstanding about what the scriptures require of Christians, that we are not, in my viewpoint, simply to do it because they say so. They don't have jurisdiction. The civil government, civil authority does not have jurisdiction in many cases. Right. So if people when we talk about that, I'm happy to talk about that too. I come from a very traditional background, religiously Baptist, so happy to talk about that.
Okay. Well, hey, I appreciate all you do. I appreciate you being with us, and it's good to talk to you again, and we'll definitely have you back. And hey, we're still going to try to get the bill through this year, the nullification bill. And once we get that video, we'll get it out to you, and we'll get it spread as far and wide as we can. But hey, thanks again, and good night to you, Jeff. I appreciate you.
Thank you, Dave. And by the way, if we have summer study, I'll try to. We're supposed to be having summer study on nullification. I'll be letting you know about that and how that goes.
Oh, absolutely. Oh, I'll be there. I will be there once we find out when that's going to be. Hey, thanks again.
Fantastic.
I got a few announcements. The Stewart County GOP will host our annual fundraiser on the 10th of August at the Stewart County Visitor Center, located at 117 Visitor Center Lane. Doors open at 4:45 p.m. Dinner starts at 5:10. In addition to Representative Jay Reedy and Senator John Stevens, we also have Gary Humble of Tennessee stands as our speaker. Tickets are $25. You can text 931-237-1026 or 931-614-8347 to purchase in advance. U.S. Constitution course starting Tuesday, September 3rd, 6 p.m. at the Fragrant Mushroom near Liberty Square in Sparta. Instructors will be Brian and Robin Gregg. It costs only $35 for the manual. Please contact Danny Blitz, the TNCSS White County leader, with questions or if you'd like to attend, you can contact her at dbflies@benland, I cannot read that, benlandman.net. This is a 12-week course that runs 90 minutes each night. Lastly, get ready for 2 days of empowering mind and defending rights. August 16th and 17th, the Cognitive Liberty Conference will be held in Nashville. Live stream tickets are still available. Find out more and purchase tickets at cognitiveliberityconference.com. Thank you all for taking the time to watch our program tonight. Please be sure to hit the like and subscribe buttons as well as the notification bell so you never miss an episode. It goes a long way to keep us bringing you the program. We appreciate your support. Check our audio podcasts on iHeartRadio, Spotify, and other platforms as well. Sign up for our weekly newsletter at our website, tninformer.com. Our guest next Monday, we will have a guest next Monday, but we'll have to announce it later in the week. Hope you'll join us. That's it for now, and good night from Paris, Tennessee, that is.